sits there and taps his hands, and you're just sitting there, and he, sits there and rocks back and forth in the chair, and a bit of another murderer or whatever he is, convicted. Up to this point of a case, not in handcuffs, not in shackles, one or the other, or both, and in orange.
Hello everybody, Excited Utterance here. My name is Hella and I have my friend in a suit, Mr. Bryan Kohberger, down to my right or the left of your screen. Yes, it's a big day for Mr. Bryan Kohberger, and it was very nice to see him in a suit. We were a little worried that he might not be appearing in a suit today in Ada County for his very first appearance there, because, as we had noted, there was a motion for him to be allowed to appear in civilian clothing, and it didn't seem like Judge Hiffler Hippler, I'm not sure if I'm pronouncing that correctly, had entertained that motion in time. But there he was, sitting up very straight indeed, like a dancer. People say I have nice posture because I'm a dancer. He had very straight posture today in court. And there is some talk about maybe it was to do with his restrictive devices that were on him. Maybe he had, we can have a look in a moment. Maybe he had some restriction on his hands or his stun belt or something like that. But he was up very nice and tall. But thank goodness he was not in a prison or jail jumpsuit, because that would have been very prejudicial, considering all along we've been seeing him in a suit. Hello everybody, good to see you. Thank you for coming over here from Dali's stream. And beautiful waterfall. Yes, you've been waiting around 15 minutes. Thank you so much for being here. Innocent, no proof yet, and they handed over all they got. Well, we'll see. So yeah, 300 and something gigabytes of new data has apparently been handed over to the defense. It could be what they call it, a needle in a haystack for them to find what they need, if it's even in there. We will see. It may just be another one of those big giant bricks of data that doesn't actually have what they're looking for, and enough to distract them for a few months. We will see. We will see. What time is it here or there? Here, over here in Australia, it's 9:35 a.m. on Friday morning. So happy Friday to the Australians, or happy Friday if you want it to be Friday where you are. Okay. Hello, Stickards. I honestly don't care one way or another if he wears a suit or not. Oh, you think he's guilty? What makes you think that? What exactly makes you think that? And I'm open to all points of view here. Open to all points of view here. All right. And the music, by the way, is The Ride of the Valkyries by Wagner. And it's part of a 10-hour opera that my dad used to play for me when I was little. If you might recognize it also from the Blues Brothers. So from the scene where they were escaping the Illinois Nazis. Okay, anyway, let's get into the hearing, guys. Now, this is a recap. And if you want to just watch the hearing with no commentary, there's plenty of places where you can watch that. That's not what this is for. This is so we can stop and chat and talk about different aspects of it. It's not going to go like super long. I'm not going to like talk at length throughout it, but because it's a short hearing, it's a really good opportunity for us to have a little bit of a chitty chat about certain aspects and then move on and still keep it to a nice sort of maybe less than an hour stream. So, yeah, you can watch it on Law and Crime. You can watch it in plenty of places if you just want to watch the hearing throughout. So let's go, guys. Just change my setup here. Just change my setup. Here we go. There we go. It is pretty good audio and things from this feed, which is nice. So slightly better than it has been in the past. Court will be beginning soon. Yes. So I was pretty close to the beginning. There it is. Hello, Rosie. Good to see you. Hey, Guy Vermectin. Look, the jury's out on whether Australia is a real country or not. Are you by France? Hello. I saw. Did you, Rosie? Were you over on CJ's stream when this was live? I need to get in touch with CJ. I keep running out of time because I've been running Sarah Boone stuff so much, and I do want to come on to CJ's stream at some point. Okay, let's go. And I need to turn the sound right up, and I need to do a little bit of a boost on the sound as well.
I was going to say.
Be seated.
Oh, calm down.
Hi, Hella.
Hello.
All right. Good afternoon. This is State v. Kohberger. I'm going to go over the appearances this afternoon on behalf of the state. Would state attorneys please represent themselves for the record?
Thank you, Your Honor. My name is Bill Thompson. I'm the Latah County prosecutor. This Ashley Jennings, she's my senior deputy. And then we have Mr. Nye and Ms. Beatty from the Attorney General's office. And then we have
First name
victim
Bill.
support staff with us.
All right. Thank you.
Yes, sir.
Defense?
Ann Taylor, attorney for Bryan Kohberger. Elisa Massa and Jay Logston, counsel for Mr. Kohberger as well.
Thank you. All right. I'd like to tell you I'm happy to be here, but why start with an untruth? I am accepting of my responsibility to be here. I want to go over with you some expectations of mine, given that I don't think any of you, other than Ms. Massoth, have appeared in front of me before. When you file memorandums.
Okay, so Miss Massa actually lives only about an hour away from this courthouse, so it's actually more convenient for her to be there than it was for her to be at Latah County. So that's pretty cool.
Yeah. And we got, so the prosecutor is Santa Claus.
Prosecutor is Santa Claus. He's going to throw a bit of shade regarding the fact that it's so very inconvenient for them to be there.
Well, yeah, he has to travel from the North Pole.
He does.
Of law, briefs, etc. Please provide a Word copy by email to my staff attorney. After today's hearing, you may get that from staff here today. Today, I know there was an issue that was brought up with respect to Mr. Kohberger's attire for today. I did issue an order yesterday permitting him to appear in civilian clothes for this hearing only.
We didn't say
That is a matter in terms of future hearings that we will take up in a closed hearing the day of, but in advance of whatever our next hearing date will be. My intention will be that Mr. Kohberger will not be present for that hearing, because part of what we will be discussing are security measures, and I expect to hear from the transport deputies and the bailiffs regarding security issues that they want to address or that I have questions for them about, so that I can make an appropriate ruling in terms of his appearance here, but weighing that not just against, of course, his rights, but also against the needs of security in this case.
Right, darling?
do expect, as it probably will come to no surprise to you, for you all to get along. I understand the stakes in this case are as high as they can possibly be in any case, but you are professionals. You have taken oaths, both as of officers within your jurisdictions, but also as attorneys before this bar. So I expect at all times for you to remain civil to one another, that you not engage in personal attacks, ad hominem attacks.
Now, you children, you can't be fighting in the back seat or I'll turn the car around and no one will be getting any slushies. No one. Right? You hear me? This is the first time and the last time I'm going to be saying it.
No reindeer treats for you, sir.
No reindeer treats. You hear me now?
Oh, God.
Telling you now.
We're going to have so many Christmas jokes.
Yeah.
And did you notice he really wanted his trial held in May, not September?
No, September. Things get really busy in September. We haven't got to that yet.
Okay. Okay. Sorry.
He's
I'm
got
premature.
so many elves. He has so many elves that he has to manage in September. Now, also, beautiful waterfall. They always make such a big issue out of the clothes. There's no skin off anyone's nose if they wear street clothes. Okay, so this was a big deal also in the Richard Allen case. And apparently it's a big deal because of security issues, right? They have to work out the security issues because you never know. He might jump over someone's desk and stab somebody. With what, I don't know. And remember the whole Judge Jumper situation, right? So the guy who jumped over the judge. Yeah. And okay, so let's assume, and you're not supposed to assume he's guilty, but let's assume he is actually a dangerous criminal. And you allow him to be in street clothes. So you have to change him out of his jail clothes and put him into street clothes in order to get him into the court environment. And that supposedly is a security risk. Doesn't he have to get changed every day anyway? Like, you need to put him in shackles to get him into the courthouse, right?
Yeah.
So what's the big deal about changing him into some street clothes and putting him in shackles, as opposed to changing him into new jumpsuit today and putting him in shackles? I don't see the big deal about that. As long as his defense counsel can get him clothes. Yeah. So I think there's more to it. It's more about the sideshow alley kind of let's gawk at the prisoner kind of aspect. Yeah. Anyway, I guess to take a guess that he forgot to file something or filed it incorrectly. Oh, that's Mr. Bowles. Yeah, no. Ann Taylor files everything perfectly. Absolutely perfectly. And her motions are written impeccably. She always cites every constitutional right that will be violated if the motion is not ruled on, and not just the constitutional rights, but the state laws as well. And she files them well and truly in time.
That you not engage in theatrics, not mistake the facts or the law to the court. And when you cite arguments in your briefs, if there is contradictory precedent, I expect to see that. I appreciate in advance what should go without saying that I've just said in terms of your responsibilities. But again, I just want to highlight that because I understand when the stakes are high, sometimes victory seems to be the objective when our first objective is to conform to the oaths that we've taken as members of the bar, as officers of this court. All right. I do have some matters with respect to scheduling that I want to go over today, but before I do that, I'd like to hear from you with respect to the matters that you either need to make me aware of or want to make me aware of.
Barbara, hi. I see you don't know much about this case. That's cool. If you could just hang about for a little bit, it's a really short hearing. We'll give you more of a rundown on it. If you have heard of the Idaho 4 stabbings, that is what this is about. So 4 students stabbed to death in Idaho back in November 2022. So Mr. Kohberger here, in this suit, he is accused of those stabbings. So, yeah, very, very high profile case. Very high profile. So Moscow, Idaho.
In our opinion, questionable evidence at this point.
Very questionable evidence. So the evidence or probable cause affidavit that was put forth back then by the law enforcement and prosecutor has basically had things like a little bit of DNA or touch DNA on a sheath of a knife that was found at the crime scene, some phone pings, so showing supposedly him driving around the area. The only reason they knew of the phone pings or decided that the phone pings were near the house were because they saw some CCTV of a white Elantra that was driving around outside the house. However, that white Elantra was never actually identified as being his. You can imagine how many white Elantras there are in the area, because there were no tags on the car either. And since then, there's actually been many of those things that have been put out have been, even by the prosecution, they've admitted that those things are not even true. So, the stalking of the victims as well was also part of the probable cause affidavit, and the prosecution has admitted that that's not true either. Pretty much all that's left is this little bit of touch DNA on the knife sheath in the house. And if you're aware of what touch DNA is, it can be transferred from one thing to another. So it's very sketchy now how the prosecution is going to continue with so little evidence on this man, considering that he didn't leave any other DNA in the house, and there is none of the victim's DNA anywhere on him, his car, or his own apartment. So here we are with him facing the death penalty for a quadruple homicide, and he never even knew these people. So let's keep going. Touch DNA absolutely is not conclusive evidence, and we know that from following the Zachariah Anderson case. And he is an innocent man who is in jail for the rest of his life, and he's missing his children. His children are missing him, and we're never going to forget or stop talking about Zachariah Anderson. He is awaiting his appeal, and if anyone would like to learn more about that, go to zachariahanderson.org, please. Free Zachariah Anderson. Absolutely. Yes, I keep going.
The other thing before I do that, though, I do know that Judge had entered a non-dissemination order. That still remains in place. And unless I, for some reason, remove that order, it will stay in place, and I expect it to be religiously adhered to by all parties, counsel, victims, counsel for the victims, and I will not tolerate violations of that. Likewise, I know that much of the evidence in this case has been subject to orders sealing under that dissemination order, or otherwise have been sealed by the court. I likewise expect everyone that has access to that information, whether it's sealed documents or information in sealed hearings or the information itself in the documents, to adhere to the confidentiality expected as it relates to those. Okay, that's my one and only lecture for you for the remainder of this case. With that,
he did say for the
let me hear
remainder
from
of the
you. We'll
case.
start with counsel for the state.
I was wondering, because Andrea said that at the end of her stream, that he said that he was only going to lecture once for the remainder of the case. Okay, we'll see about that, Judge, because he does seem the kind to do lectures, doesn't he? He's sitting up there on his podium, literally on his podium, lecturing. And my first impression of him is he's a bit of a daddy figure, and I don't mean that in a nice way. Yeah, not at all.
Oh, daddy.
Like he's not oh daddy, no, in a very stern, gruff kind of way. Like, I'm going to sit here and I'm going to tell you guys what's up. And this is how it's going to be. And I didn't like the way he was also continuing to talk about this non-dissemination order. Everyone just needs to keep hush-hush. Everyone needs to keep quiet. He did mention the victims too. Remember, we have one victim's family who has gone above and beyond to talk as much as possible about the case, going so far as to leak information recently about the change of venue order before it was released to the public.
Is that what he's talking about?
It could be. It could be. I think that probably is something like that, yeah. So there is that. But so much of this case has been kept under seal. There are literally hundreds of documents that are under seal, exhibits and documents under seal. So much stuff's been kept in camera. It's just not transparent at all. So, and he seems to be keeping it that way, which is a shame. I had hopes that he would be more transparent, but it's the first day. Let's see.
Your Honor, I don't know that we have specific questions we want to propose today. We're looking forward to hearing the scheduling. I think that's going to drive, for us, particularly the distance involved, any questions that we may have. I appreciate what you've already mentioned to us, and we will certainly honor all of that. Thank you, sir.
Taylor?
Thank you, Your Honor. There are a few issues that I wanted to make the court aware of as the court decides on the scheduling order. We want the court to know that our team has been working towards the June of 2025 trial date that had been issued by judge in the case. But in candor to the court, I need to let the court know some issues that have come up that we face that causes me concern. First, the court's probably aware of the vast amount of discovery that's been exchanged in the case by reviewing the record. But since August, we have received about 398 gigabytes of new information, and I can tell the court that nobody on the team has read every bit of that yet. So there's a vast amount of discovery to continue to go through, and I wanted the court to be aware of that.
That's
the
really
second thing
interesting.
is that during the course of this case, we had an expert that we were working with, and that expert passed away. We have been able to...
Okay. This is going to be a big deal. This is going to be a really big deal. They have had an expert pass away. They have something like 25 expert witnesses for the defense. That's huge, right? So this is one crack defense team. Ann Taylor, she's a legend, the one standing up. She is a fantastic defense attorney, and her team, Eliza Mathoth and Jay Logston, they're all fantastic. He has scored big time with this team, right? Now, they've had an expert pass away, and he's a mitigation expert. Oh, she, sorry, is a mitigation expert, is what I found out. And this has only just come to light in the last couple of hours. Mitigation expert is somebody who argues, in this case, against the death penalty. So that would be for the death penalty phase, assuming that he's found guilty, right? Now, the expert, the deadline for disclosing their experts is around May. I believe that's what they're about to talk about. So that means that starting the trial anytime around then is kind of off the table now, because that defense expert has died. That's not her fault, right? That's,
Well,
yeah, we'll see.
Did she have
But
a poor diet?
keep that in mind, because everyone who is basically against Kohberger has been saying that the defense has been dragging this thing out. Have a look at some of my previous videos on this. The defense is not the party who has been dragging this out. The state just handed over 300 and something gigabytes of data. 6 motions to compel it has taken for that data to be handed over. And I tell you what, 367 gigabytes of data is not required for the actual items that they have been asking for. They're going to have to sift through that for months to try and find what they actually need. Yeah. So, and who knows whether it's even there. There still could be another motion to compel in January, February, and they still could not have what they need. So the state has been holding back really critical information, like cell phone data showing that Kohberger was 40 miles to the west at the time of the alleged crime. So,
And just for instance, Sarah Boone trial, most of the evidence we got was 7 gigabytes.
oh yeah, we got the discovery for that. That was 7
A lot
gigabytes.
of it,
Yeah.
Hannah Reed was, or the Rush shooting whole thing was like around that as well, maybe 10, less than 10.
We have no idea what it is, what this data is, but like they have, for example, they have requested the IgG data, right? So that is most probably stuff that has been provided by some outside source by a subpoena, and it would include lots and lots of people's DNA information, right? And so that, and not just DNA information, all of the reports that go along with that, all of the medical information, etc. I don't know if that's, I don't know whether the HIPAA stuff would be involved, but like the stuff that people disclose when they go to like 23andMe or Ancestry.com, that would have been subpoenaed via the genealogy request to compel, right? So the defense has requested, put it in the motion to compel for the IgG, and so therefore they get all this stuff back. Then they have to find a way to go through all that. Now they might not have the expertise to go through all that, so they have to get an expert to go through all that. Then they might not even find what they're looking for because the state just forgot or didn't understand, or maybe they didn't ask for exactly the right thing. And then we get to February, March next year, and we need another motion to compel. So, well, it's not that simple, is it? Because if there's, you know what could happen? It could get to the middle of trial, and we could end up with a Brady violation because the state realizes that, hey, the defense realizes, hey, here's a bit of evidence that you haven't given us, state, and you haven't given us time to prepare that, and we could have a Brady violation that ends up in a Baldwin style dismissal with prejudice. And he walks completely. Or it's a mistrial. Yeah. So I don't know if you watched the Baldwin trial, but 3 days in, you want to say what happened?
They found out that the police or the state had information that they did not turn over. Mm-hmm. They had actually discovered the source of the ammunition, and it was dismissed. Long story short. Yeah.
So the case was dismissed, and Baldwin walked. That was it. And yeah, walkie walk. So would you like that to happen? Steal STL cards? Because I think you believe he's guilty, right? So that's
okay
happen.
If you do. It's just
it's fine. I think you believe he's guilty. So if you would like that to happen, if you want that to be the end result, that is exactly what could happen if all of this information is not handed over by the state.
Yeah.
Yeah, exactly. All right, let's keep going.
Refill that role to have a new expert to do the work that expert was hired to do, but we are not progressed to the point that I'd hope to be through no fault of the new expert. The court should be aware of that as well. And last, as the court is very well aware, the system of delivering public defense is changing next week. As appointed counsel in the case, I do not have a contract yet, Nobody on my team is under contract for this case. I'm concerned about what that means, and I thought the court should be aware. Further, we have been able to access funding to help us prepare this case through Idaho Criminal Rule 12.2. At the current time, we're working with about 25 experts and investigators to prepare the case. I don't know if 12.2 will continue to be the way to get funding for those experts and investigators, or if that's changing. And I thought the court should know those things. Thank you.
Thank you. So I am hopeful that Mr. Frederickson will ensure that a contract is available for you and your team next week. I have no control over that, of course, other than to, as it relates to who I permit to withdraw from this case or not withdraw from this case. As to 12.2 funding, my understanding is, and I've had a discussion with Judge Munson, who has been serving, as I understand it, as what we refer to as the money judge. I've asked him to remain in that capacity at least through the transition to the state public defense system in next week on October 1. My understanding is, and perhaps I will come to find out something different, that once it goes to that system 12.2 as it relates to public defense funded attorneys on contract seeking 12.2 funding, that's no longer a thing, that would come through the state public defense budget, essentially. I guess we'll find out if that becomes a problem down the road, but that's my understanding, because that whole system that 12.2 is based upon is coming to an end. So, given your statement about the trial date, my proposal to move this case forward into May is probably not going to land well with you, but that's what I wanted to talk about, is the timing of the trial. I'm concerned with a trial as currently set for a number of reasons, but first I want to find out you, as you sit here today, what that trial looks like in terms of the number of weeks of trial, starting from after a jury is selected through the end of the evidence and before any potential sentencing phase. So what are your estimates of that?
Your Honor, I think it would be a fair estimate based on what we know at this point to have a month and a half or perhaps a bit more just for the evidence for the guilt phase of the trial. I say that knowing...
Is that just your evidence, or does that include defense evidence?
Well, I was just getting ready to say, I say that understanding or acknowledging that Ms. Taylor has estimated 2 to 3 months total. I do not know. We do not know what the defense has in mind for their case right now, so all I can speak to is what we anticipate for ourselves. But I would think that the state's evidence in chief should be able to come in a month and a half or so.
Okay. Ms. Taylor?
Your Honor, we estimate 4 weeks for the defense portion of the trial case.
That is,
Of the guilt case?
Yes, Your Honor.
there only will be a guilt phase, Your Honor.
So 10 weeks. In terms of if there is a
Hello.
penalty phase, should the defendant be convicted of one of the statutory qualifying offenses, how long do we estimate the penalty phase being?
You're right. From the state's perspective, I believe we're going to be relying heavily on the evidence that's introduced during the guilt phase, and the additional evidence that would be brought in, unless there's something we learned from the defense about their experts, is probably more than a week.
Taylor?
Your Honor, I would estimate 2 weeks for that part of any trial.
That's
For our evidence.
For your evidence?
Yes.
Okay.
just so you guys are aware, the defense counsel has put in, I think it's 8, might be more, motions to strike the death penalty. They did that just in time for the deadline. So some people were very critical of that, and they said, oh, look, there's the defense admitting that he's guilty because they're putting in these motions about the death penalty. That's ridiculous. There is a deadline for motions to strike the death penalty, and they put those motions in. Jay Logston there, this fella on the very far left, 2 down from Bryan Kohberger, he is a specialist in constitutional law, and he authored most of the motions to strike the death penalty. They're extremely long. There's one of them that's like 144 pages, and in depth. But I think that there will be some sanctions against the state for all of the time that they have wasted not handing over so much information in regard to these motions to compel. And I think that the defense will be using that as a leverage to strike the death penalty. So I don't think there's going to be a mitigation phase or a sentencing phase that is in light of the death penalty. Don't think that they're too worried about that.
So my concern, because this trial is currently set to begin June 2nd and end approximately August 31st, is having it set to run the entire course of the summer, I think we will find to be difficult on jurors in particular. Jurors who may have children who are out of school in terms of being able to spend time, go on vacations with them, et cetera. That's one concern. The second concern is with school that typically starts in mid to late August, and jurors or parents who may have kids going off to school, the timing of that through August. And that's my primary concern about that time frame. I had 2 proposals. One was to start the trial in the evidence portion of the trial the first week of May, and the other would be to start the evidence in early September. And I'd like your thoughts on this. I'm not saying I'm have or necessarily will vacate the June trial, but I want to look at alternatives here because I am concerned about that spread that takes the entirety of the summer.
And we hear you, Your Honor. By way of history, the summer, we advocated for that in Latah County because the courthouse is right across from the high school and the summer would have the students gone. If we were looking at the other 2 choices, we would propose May.
Taylor?
Thank you, Your Honor. Your Honor, I would have to advocate for September at this point based on the 3 reasons that I gave the court before.
So I'm not going to worry about the public defense change because I think that will take care of itself. The one thing that you brought up the most, I mean, I understand there's a lot of evidence, but May is not tomorrow. May is many months away. So the one that concerns me that you brought up is your expert.
Yeah, that's a problem.
I'm not asking you necessarily to give away any secrets prematurely that you may have in terms of defense strategy, but can you help me understand this expert if you're able to, and what their role is and what the prospects are?
Your Honor, it's really difficult to tell you much about the expert without giving away a lot. I can tell you that this is a very necessary expert for us to have on board. We've been able to find somebody to fill the role. I'm confident in the person that will fill the role. There just hasn't been enough time to get the work accomplished yet. I know that that doesn't tell the court a whole lot more than what I said before, but I really feel that that would disclose too much for me to say more. I could do so on an ex parte basis or with Judge Monson, our resource judge, but not in a public setting.
I understand. Do you anticipate being able to fulfill your obligations for your current expert disclosure deadline that was set by Judge?
No, not with a lot of confidence. I think that the work is going to take longer than to meet that deadline. I think if we met that deadline, I would have additional information that I would want to be able to present, and maybe I would have been stopped from that with that deadline.
So I don't have a motion to extend that date, obviously, and with the changes that occurred, I understand why you didn't file one out of the box, but the deadline, I think, is January 6th, something like that, if I'm not mistaken, for experts on the defense side.
That's one of our deadlines, Your Honor, yes.
I guess, does the state have anything to say in response?
Not knowing the details of the challenges Ms. Taylor and her team are facing, I don't really know how to respond further, Your Honor.
Ho, ho, ho.
What do you think is a realistic deadline for you to be able to disclose your experts for everything? I'm assuming it was January, all save that one expert. But with respect to the expert you had to replace, when do you think you could disclose consistent with the scheduling order?
Other than the expert that had to be replaced, Your Honor, there were two separate deadlines. One was for trial experts and one was for mitigation experts. And I believe that I can make that deadline other than that one expert.
Can you tell me if the one expert is a mitigation or a trial expert?
A mitigation expert, Your Honor.
And what do you think you need for that mitigation expert in terms of a deadline? Compared to that mitigation deadline was,
I believe it was March. I don't recall the exact date.
yeah, so that's a long time from now. So
Really, I'm going to be busy after September, so you got to be done by
I have a lot of questions, but I'm hesitant to ask you the questions because
Where do
I'm
babies
sure
come
you're
from?
not in a position to answer
January's
them
my
currently,
holiday.
given the forum. So, but
February
March is
to
a long
May is
time
about
from
it.
now.
Your Honor, the time passes very rapidly, and I appreciate the court not asking questions I can't answer.
Got a long
I
list
think
to
if I
check.
had an end of April
Gotta see if the
deadline
defendant is
for that
naughty or
one
nice.
witness, I think we could make that deadline.
Going to have to give the defendant some coal. Ho, ho, ho. God damn it, Rudolph. Don't take a shit over there.
Stop it.
You're potty trained. You know better, Rudolph. The jokes are going to be epic.
It's good. Yeah.
Big stocking. This prosecutor has big stocking.
It's just looking at the film.
So, understanding this is a mitigation expert, Thompson, how concerned are you about getting that disclosure closer to trial?
closer to trial is somewhat relative. The end of April sounds like it would be on the eve of trial from the date the court is proposing. I think that would be, I'm not sure that would be realistic. And again, I'm not in a position to second guess
Sure.
what Ms. Taylor and her team are representing to the court. She had told us some time back that one of her experts had some health issues, and I think that she did
hang
tell us
on.
that that person had passed away and they were working on a replacement.
Now we're sus on end.
If we're looking at a mitigation disclosure at the end of April, I don't know that we could be ready with all the final
no,
trial
you can't
preparation
be
for a
ready,
May
Santa.
trial. I hate to say that. I feel like I'm cutting my own throat in a sense, but that's realistic.
Cutting your own throat, that's really bad taste.
Come on, Santa. That's
Come
kind of
on now.
offensive, insensitive.
Well, I
You-
can do
you need
one
to
of two
turn up
things.
your mic.
I can set a separate hearing ex parte
Okay.
to explore
better.
this further, but I frankly don't know how far that's going to get me. I mean, I can set a date, and my experience tells me that date will be complied with regardless, right? Yeah, 24 hours in a day, but if you use enough of those hours, enough days in a row, you get it done if you have to. At the same time, I don't want to put unrealistic deadlines. And so I can do that. I can have an ex parte hearing,
Yep.
or we can go ahead and reserve September.
Works so well in Young Thug.
I will throw it to Mr. Thompson as what you want, what you would advocate for.
Yar, could I have just a moment?
Okay. Okay. So let's catch up.
I got a plan.
Why isn't Judge there? It's a whole different courthouse, Ronnie. Like, you know how there was a change of venue motion? It happened. And it happened so fast. Like, the very last hearing was about the change of motion, change of venue, and now it was approved. And Judge was like, "Fuck you all.
Suckers, bye.
Bye, suckers. See ya. This is my chance to get the fuck out of here. There's a lot of corruption and stuff, and I am not part of it. I'm going back to my cushy old life. See you. Bye," as Snake would say. And, yeah, so it happened. And they put Kohberger onto, like, a private helicopter or flight or whatever it was, and, of course, the Gonclaves were all like, "Oh, he's on a
Really?
private flight."
They didn't drive him?
No, they chucked him on a little chopper or something.
Lucky?
I
I
know,
want to
right?
go on a helicopter.
Me too. Yeah, with shackles and stuff. That'd be great. And,
I don't care.
And then they gave him a pretty new mugshot when he got to the local Ada County jail. He looked really good. Like, he looked really... And people were pissed about that. Did he look good? And now, the very next hearing... Oh, yeah, P.S. What happened in between was obviously got a new judge, and the new judge took all of the court dates, motions, hearings, and trial and went, pew, pew, put a big red pen through the whole lot. Done. So here we are, very next hearing, and everyone's had to travel, and Santa's very unhappy about that because he had to travel like 7 hours, and he continues to talk about it. Yeah. And yeah, here we are in Boise, Ada County, Boise. Yeah, which is in the south, I believe. Tell me if I'm wrong. I wouldn't have a clue. I think it's south. Women are swooning over him. Apparently, he's not a bad looking dude. I mean, he's a bit pale.
Wilson?
Yeah, he's no Wade Wilson. Are they putting money on his case? I don't know. Look, Anne Taylor is really clever, and she, I'm sure, has him really, and he does what he's told. Bryan does what he's told. He's never spoken a word, right? We've never heard a word from him. He has just behaved himself perfectly, and if there's girls sending him things, we don't hear anything about it. We hear nothing. So yeah, I'm sure he is behaving perfectly in jail. Absolutely. The mugshot with gin. Yeah. Yeah, he's got lovely hair and his eyebrows aren't bushy at all, and people are pissed about that. They're like, surely he's had them groomed because he has bushy eyebrows. No, he doesn't. Bryan's babes. Yeah. All right, let's keep going. You sent nudies, but he never responded. Yeah, I wouldn't think he'd respond. Diane,
Your Honor, we trust the
much
court
as
to
he'd
do
love
the
that.
ex parte hearing, see what's there, and make the best decision, and tell us what the expectations are.
Do you want to do that later today, or you want to do it tomorrow? You need time? You want to come back next week?
Your Honor, I had planned to leave town today. I have other case-related obligations tomorrow. I could do it as soon as this hearing's over if the court has time, or I can come back next week at the court's convenience.
I think we'll probably be finished in here by 3 if we were to do it immediately after. Are you comfortable with that? Does that give you enough time to get to the airport?
Yes, I believe it will, Your Honor.
All right. Well, we'll give that a shot. All right. If I move this one way or the other, I will adjust the various deadlines that are in here.
Young.
I-
Hang on. I'll share this tab instead for a second. There's his new mugshot.
Ooh, he's a werewolf.
Look at him. He looks so much better than he had before. Like, he's gained a bit of weight. Like, back when his first mugshot was taken, he looked really unhealthy. Like, he looked...
His eyebrows aren't that bushy, by the way.
They're not bushy. No, did you just hear what I said about the bushy eyebrows? Like, people were saying...
no.
People have been saying that he had his eyebrows groomed for that.
He's a groomer.
He's a groomer. Yeah, people have legit been saying that he's had his eyebrows trimmed. That's ridiculous. He has never had bushy eyebrows. Like, no more bushy than any man's. Like, not like Santa's. Santa's got
Yeah.
bushy eyebrows.
Maybe he did
And
it.
like, look at his pretty hair.
Yeah.
His hair's perfect. It's like
Rawr.
it's like shiny and curly.
I need a
and,
haircut.
like, from a shampoo ad.
I need a haircut. I'm going to take this picture, go to my barber, and get this haircut.
Oh, Steve said that. Steve Conclavis said that he had his eyebrows done. So that's one of the victim's parents. If you're not aware, there is one of the victim's parents who have been very loud and very inflammatory
Proud.
towards the defendant, and it's quite sad, actually. In fact, yeah, his first mugshot, he was probably in a shocked face. Yeah, like his skin looked like
Yeah.
grey. It was really sad. Anyway, let's just go back to watch the end of this. It's almost finished. Hello.
Hello.
It's thinking about it. Am I having the same problem you were having earlier?
Won't adjust the next deadline that you have, understanding that you may be already committed to it, which I think is the motions related to the defense's motion regarding the death penalty, if I'm not mistaken. Is that the next set of hearings we have?
Those are now scheduled.
I believe that our briefs are due the 10th of next month, with the hearing later this fall and a reply brief deadline for the defense. And we are on track to meet those deadlines, Your Honor.
I'm sorry, you were saying, counsel?
Your Honor, I'm guessing the court has received our motions already. I believe we were set for November the 7th.
I think the state's deadline for discovery has passed. Has the
Passed.
state complied with its discovery obligations, including those outlined in Judge's last order and other orders?
We have, Your Honor, and in fact,
Thank you.
Ms. Jennings prepared a lengthy summary of all the discovery that was filed with the Latah County Court when our discovery deadline hit. It is lengthy, but there's a lot of discovery.
Sure.
We recognize that.
How much of the, you say 300 gigabytes?
398 since August
How
13th.
much of that is new information?
Ms. Jennings could speak to that.
Ms. Jennings, can you speak to that?
Miss Jennings.
Your Honor, the defense was given, and I'm not sure if this is what they're referencing, but they were given a copy of the OneDrive from the FBI. Most of that was cumulative discovery that they had already received in another fashion. I'm sure there were portions of it that was new information. I've not calculated how much of that was new. So I can only rely on Ms. Taylor's, what
Ms.
she's
Jennings,
represented to the court on
You
that.
gave it to her. You should know.
Well, I don't think she knows because it doesn't sound like she's looked at it yet.
All of it.
It's a lot of information.
All right. Well, I will talk when we're finished here with Ms. Taylor without the state present in a closed hearing. What else do we need to talk about today, or do you want to talk about today?
Bye, Barbara.
Hi, Barbara. Erica. Oh, Barbara.
Nothing comes to mind right now, Judge. I know that there will be plenty of opportunity for other discussions. As far as your meeting with defense ex parte, do you want the state for any reason to stay around, or
Wait a minute.
would you like us to get on the road back to
Sorry.
Moscow?
Are you flying or driving?
Driving?
Okay. Well, why don't you hang around just in case we need.
Okay. Look at Eliza looking at Ann Taylor. Can you see her staring at Ann Taylor? She's like, yeah. They were just talking about that discovery that was handed over, and Miss Jennings was like, oh, in that 390 whatever it was gigabytes, there's stuff from the FBI, but it could be cumulative. Some of it's new. I don't know. Right? She doesn't know what's in there. Right? She hasn't looked either. She's just gone, oh, I gave you the OneDrive. Right? So
This trial is sponsored by Microsoft, by the way.
yeah, right? So she's just gone, oh, here's a link. Like that. Our responsibility is fulfilled, done. Like that. It could be exactly the same shit that they handed over before, with a couple of extra files, and that could be completely irrelevant and hidden in nearly 400 gigabytes of crap that they already have. Right? So why so sour at the state? Because they've been messing about for nearly 2 years. There's been 6 motions to compel and how countless other supplemental motions for discovery. Right? They've been absolutely screwing about the PCA. Most of the stuff in the PCA now has been discredited, even by the state themselves, right? There is just about nothing on this guy. There's so little on this guy. He should be out. He should be on bond at least. He should be on bond at least. This is stupid.
You don't get bond for a DP case.
It shouldn't be well.
Yeah,
They've
I
got
get it.
nothing on him though. They have like all the things they put out in the beginning, they have gone and had to retract. He didn't stalk them. He wasn't actually driving down the street outside their house, right? The cell tower stuff, they've got, that doesn't even hold water anymore. All they've got is a tiny little bit of touch DNA, and they got a lack of any DNA of his anywhere else in the house, and they've got no DNA of the victims anywhere on him, in his property, in his car. They said they did, but they didn't. It never came forth. There's all of this tons of evidence that they said they were going to have. Where is it? They never came out with it. It doesn't exist. So their case has completely fallen apart. It's completely fallen apart. That's why I'm pissed with them. I find that hard to believe, and his lawyer wouldn't be fighting that. She is she's fighting it. She's been fighting it hard. She's said it several times, many times. EU wrote Hiffler on my eyes are blurry. Oh, I might have misspelled it wrong. Yeah. You don't have to believe they're the facts. Yeah, Diane knows. Yeah, there's a few of us have been following this really closely, and yeah, this is the truth. It's the truth. There are hundreds of documents that are under seal, and Ann Taylor has been documenting the numerous times that the state has withheld very important evidence, and then they have just gone and said, oh, well, the FBI did that work. And then the defense has come along and gone, great, well, can you talk to your friends at the FBI? And then they've gone and cited the TUI rule. So TUI rule is supposed to be for national security, for example. Things are bad when the TUI rule gets called in to hide potentially exculpatory evidence. So, no, not the, well, she's not going to argue the entire PCA is bullshit. She's argued pieces of the PCA are invalid, and she has successfully. And in fact, the state has come back. At one point, the state actually came back, and in a footnote in one of their documents, they said the probable cause affidavit is irrelevant. They actually said that. This was a few months ago. They had to write the probable cause affidavit is irrelevant. Yeah. Anyway, so that is pretty much the end of that. Hang on, we'll just see if it ends.
Need to, if I'm able to make a decision based on that, I can inform you what that is at least.
Yes, sir. Thank you.
Anything further, other than your your motions regarding the death penalty? Do you have any outstanding motions, and the motion as it relates to Mr. Kohberger's attire?
Your Honor, there's no outstanding motions right now. I do anticipate filing several motions in the motion to compel deadline. As far as discovery goes, I anticipate there may be some follow-up motions. I, of course, first try to speak with the prosecutor to resolve those.
All right. I think you will find I'm probably more inclined to hear things more quickly than you're perhaps accustomed to in this case. So just be aware of that.
Is that shade it does, Judge?
Probably more along the usual, 14-day timeline with respect to motions. If there's a lot that needs to be done with respect to them, we can talk about that. But
Oh, I missed that before.
On that point, Your Honor, as you can see, they're a multifaceted team. And on motions, we try to assign them to specific attorneys. On various motions, would it be acceptable to the court for those attorneys who are not actively arguing the motions to be able to participate remotely? Or would you like us to be present? We're happy to do either.
I'm fine with that. I just prefer those that are going to be arguing to be here, just because it makes it easier to have that dialogue. So,
Okay, thank you.
the others,
Wow,
if
he
they want
did,
to
didn't
appear remotely, that's fine.
Thank you.
And same for defense as well, depending on what defense wants to do.
Wow, that was really shady.
All right. Then if there's nothing else this morning or this afternoon, I guess we will be adjourned and have a discussion in a few minutes. All right?
Thank you, Your Honor.
Back in a few minutes once the courtroom is cleared.
Okay. So,
I'm gonna head out.
yeah, you go. That's cool. Dali's a bit tired, a bit sleepy.
Long day.
You need a bit sleepy.
You bit.
Sorry.
All right. All right. Thank you, guys. I will
you.
see you later.
Okay. All right. So you'll be in the chat. See ya. Alrighty. So yes, online Judge Hiffler threw shade at everyone, didn't he? He was like, "You're all going to behave, and you're not going to make personal attacks of people or ad hominem attacks, and I can. You don't have to have a 14-day turnaround with me. You probably." it'll be a little bit quicker than you're accustomed to. So goodness me, geez, aren't you the best, Judge? Aren't you just the best, the bestie, the bestie, the bestie? Alrighty, so what I wanted to do now is have a little bit of a look at these, which I always like to do after one of these things goes live. So let's have a bit of a, yeah, okay. So the comments section, everybody. Let's take Mr. Kohberger down for a minute. He probably doesn't want to see these. The comment section. Judge is straight talker, not a defense-pleasing pushover. That would be shade at Judge, because apparently he was a defense-pleasing pushover, everybody. Okay. Guys, I think he was eating beans and rice in jail. I think that was his general staple diet as a vegan. That was his special meal that he got. Let's get it going. Defense pushover, how delusional are you? Judge was always annoyed with AT and favored prosecution with deadlines. Just because he made fair decision moving trial doesn't mean he was favoring defense. What an embarrassing comment for you. And he doesn't party with the prosecutor either. Ooh, who does that? My crime time. You mean the Goncalves family will start crying about the new judge once he makes a decision they don't like when the defense try to get a new judge? Look, we all know that's going to happen. We all know it's going to happen. The Goncalves family, unfortunately, here's the problem, guys. And I hate that I'm at a point where I feel this way about these people. I hate it. But I'm out of sympathy for their behavior. Not so much for them, but for their behavior. The poison that they've spread about not just about Bryan Kohberger, but also about the defense attorneys, that really bothers me. That really bothers me. The way they actually talk about the defense attorneys. One of them actually said something along the lines of, we hope that Bryan slits Anne's throat or something like that. So leans over and slits her throat to make it quicker or something. I can't remember the exact wording, but one of them said something like that. And I'm sorry. I'm out of sympathy. It's just gotten so bad. Yeah, it was foul. If you haven't noticed, because I've gotten really upset with some people on the Boone case as well, who've been saying just terrible things about the lawyers who've stepped up to help Sarah Boone. I don't like it when people start going after the lawyers. I only sympathize with the fact they lost a child. No parent deserves that, of course. And that's why I say to you guys, I hate that I feel this way towards them, but their behavior day after day after day is just, I can't condone it. I just cannot condone it. The begging needs to stop too. They got over 250K and nothing went to a good cause. Yeah, and so the most recent thing is they have a GoFundMe up for $50,000, and they're up to, where are we? Actually, I'll show you the fundraiser. Here it is. They're up to $39,370 to help them get to the trial. Yet the state covers that. So, yeah, apparently the state covers all the costs for that. So, I'm not in the US. Guys, correct me if I'm wrong, but I believe that it happened for Zach's family. They covered the cost of the family being there, and that was the defendant's family. Lots of people have been commenting on this actual GoFundMe and on their page as well, and in other forums, saying, but this is not necessary. Even if you were to travel backwards and forwards or even rent a house, the state would cover all that. And even lost income, they cover that. So, and that's not including Venmo payments. No. The state, what's this, John? The state doesn't pay the family's bills, so they don't have to work, I don't think. Sadie asked for Zach to pay for her. Okay. Regardless. Yeah. So her family is how far away? 6 hours, I think. Yeah. So Idaho's a pretty big state, apparently. I don't know. Must be 6 hours drive is fair way. Apparently, guys, I don't live there. So if you know better information than I do, I'm really happy to be corrected. I've just seen a lot of comments of people saying that. Yeah. Oh, they still work? Okay. How do they work, though? If you want to be at something every day, how are you going to work? That's your choice if you're going to be there every day. 6 hours is not too much to Americans, isn't it? We've got a pretty big white landscape here, too. All right. Anyway, let's get back to the comments for a sec. All right. So I want to show you some other things. Oops, wrong one. Oh, no. No, that's the right one. Okay. The defense keeps trying to push the trial out as far as possible in hopes people forget how absolutely vicious these murders were. Okay, yeah, righto. But I have a feeling no amount of time is going to soften the blow of this heinous act once the evidence is produced. Yeah, we're still waiting for the evidence. It's been nearly 2 years. So yeah, they said they were going to have some evidence at some point. Totally agree. The moving of the trial is going to backfire. For whom? I like this judge. It'd be nice if this person would say why. Judge, I'm high-fiving you. Victims' families deserve no nonsense. Okay? This judge ain't taking no messin'. Ann Taylor, too many delays. Get to work. Let's get this done and give these families some peace. This is because she has nothing to work with. Okay, whoever this My Crime Time is doesn't know what they're talking about. Actually, I think I've seen this My Crime Time before. Oh, hey, Rachel. How are you? Diane, do you know who this My Crime Time person is? She has 25 experts. 25. I haven't seen many, if any, from the state at all. 25 experts. Do you know how much work it takes to get 25 experts on board? Like a lot. A lot. And if you've seen the amount of paperwork there is on the server, she has been working her ass off. Like, this woman is a gun. She is really one of the best attorneys I have ever seen do work. Like, she just blows my mind. I have the biggest law crush on this woman. So yeah, and to say she's got nothing to work with, well, she's already defended this case to so many people. If you were to look a year ago at the comments sections on most of these streams, they were all, he's just so guilty, there's so much evidence, Whereas now, if you search Bryan Kohberger up, you'll see so many people saying that he's innocent, they've got the wrong guy. There are so many people who think that this is a complete injustice now. A year ago, that was not the case. Now, due to her hard work, there's a giant community of people who completely believe that he's innocent, and as they should. It's innocent till proven guilty, and there's just no evidence. You're slowly dying inside. Hey David Young, I went for a bike ride to burn off the beer. Oh, good, that's good. Yeah, never seen it. Exactly. All right, so the first judge set this for June, and this judge is simply is trying to simply move it to May, and now the public defender pushing to September. This is so ridiculous. No lotion to extend the date. Too bad, chica. Okay, we'll get to the good one. Oh, here we go. What about the families? They have been waiting for justice. Start in May. All right, this really pisses me off. There is not the family's trial. The trial is called Idaho versus Bryan C. Kohberger. It's his trial. Unfortunately, the families seem to think, well, one of the families at least, seems to think that the trial is for them. It's not. If he's found guilty, then the sentencing phase is when they can come in and speak and heal and all that kind of stuff. But the actual trial is for when he gets to have his justice, his turn at seeking justice. So when people sort of say justice for the Goncalves, justice for Ethan, justice for whoever, and then they look towards Bryan Kohberger, it's kind of a bit mixed up, and it's why I tend to go justice for the for the defendant first, because the defendant's the one who is facing justice in a court of law. They're innocent. He's innocent. We should be looking at them as innocent first, and then having the state convince us that they're guilty. Unless there's like something really, really clear, like so many people saw them do it. Like Darrell Brooks, for example, right? So many people saw him do it. It's very difficult to presume innocence in that case. However, if the state were to overcharge someone like that, which is pretty difficult to overcharge Darrell Brooks, but if the state were to overcharge, then you need to relook at that. But almost always, we're not there. We don't see it. It's very difficult to be really sure that the person is being charged correctly and that they are guilty until we've seen the trial. Yeah, well, we don't want to scapegoat appeal either. Everybody just wants to rush this through and not think about the ramifications of doing that. Should something be missed and Kohberger has the right to appeal, we need to make this as sealed tight as possible for them to do that. Everything needs to be laid out and discovered. Can't rush justice. Sarah Boone was in 2020 and her trial hasn't started yet either. Oh, isn't it funny that we're talking about Sarah Boone now on this channel? Because tomorrow is the Sarah Boone hearing, and I sure hope the court audio works, because there's going to be a lot of people on Zoom tomorrow. Eek. Okay, this is my favorite one, guys. Ready? Oh, hey, Travion. Well, that's an interesting point. To be fair, they're part of the state, so it's their trial as well. No. Sean will fight you on this one too. So there's only one person entitled to a fair trial, and that is the defendant. The state is not entitled to a fair trial. The defendant is the only person entitled to a fair trial. So, fight me on that. Fight me on that. If anyone wants to criticize my online behavior, blame it on Young. I went to her for therapy. Did you? Well, that was smart. Hey, hello, Dina. Good to see you. Good to see you. Can't quite get in line on that one. What's that one? Get in line. Oh, go back with Sarah. Okay, this is the one I wanted to read out. The public defender is basically putting this trial off further and further. I know the families are sick of the crap. Oh, yeah, we know that. Her expert died. What the hell? New judge ain't having none of that. None of it. Thank goodness. Should have a backup on call. Doesn't take long. Exactly. What the heck? geez, they have so many years already to get ready to start the trial already. It's a mitigation expert. They have to force the prosecution to give them disclosure on how many times now, and still stuff gets dropped out. Why not give it all the first time? Yeah, that's fair. This bit, okay, died or quit on her. She needs to bring an obituary and death certificate to the ex parte meeting. Oh my God. What? What is this? Is this person kidding? Died or quit on her. She needs to bring an obituary and death certificate to the ex parte meeting. What? Okay. Like, that's funny, but I guarantee there will be people who are like, seriously, did she really die? And did she know she was going to die because she's been sick? And she should have known she was going to die, so she should have had a backup. And in fact, I reckon she did kind of have a backup because she's got someone already. Like, she did say that she's found somebody already, but the work hasn't been done. So there's like these mitigation experts, they do like long-term work. Like, they get to know the person and the family and that kind of thing. So now this other person has to step in. By the way, mitigation experts, hang on, where's David said something. The mitigation expert is there to testify in the penalty phase. Should he be convicted and they attempt to sentence him to death, it's a very critical witness. Yes. So they're there basically to argue that he shouldn't die. And yeah, they tend to know a lot about the witness. Sorry, the defendant. I know a lot about the defendant and like his past and whether he's been a good person throughout his life and what, you know, things about his family and whether or not they're going to need him in future and things like that. So yeah, the new person who would take on that role needs to start over again right now. Yeah. And this was part of actually their motion to strike the death penalty argument, was that his constitutional rights, there's a tension between two of his constitutional rights, because one of them was his right to a speedy trial, and then there's this other one which is to do with the deadline for striking the death penalty. So if it's a death penalty case, then there needs to be this mitigation phase. And so the work required... Hello. Come here. Oops. Come here. The work required to do... to prepare for a death penalty case, like have someone on board, like this mitigation expert, to do the work for a death penalty or mitigation phase, is far too in-depth to be done within the phase of a speedy trial. So how can it be possible for a defendant to choose between having their speedy trial and not having a death penalty, right? So you can't have a death penalty case within the speedy trial period. So basically you're choosing between two of your constitutional rights. And that's in one of the documents that is there for motion to strike the death penalty. It's very interesting. And I'm not actually, well, obviously I'm not an American and don't know that much about the Constitution, but I found that very interesting because of the fact that he is being asked to choose between two of his constitutional rights. But then again, so would anybody be if they were in that situation. So how is he different to any other defendant in that situation? He did have to choose to waive his speedy trial in order for his defense counsel to be able to prepare for a potential death penalty. You're right, excited. It's a contradiction. And Sophie's choice. Yeah. I'm an honorary American? Why, thank you. Who's demonetized now? Oh, well. It sucks. I knew she was going to keep pushing it off. I hope the judge will stick to the date. Look, she's only... People make it sound like Ann Taylor is putting off the trial for some sort of nefarious kind of reason. It's because she needs to defend her client. And what's wrong with defending her client? That's her job. And she's doing a great job of it. She's doing fantastic. It's crazy to me this is even acceptable at all. How many years now has it been? 2? 2. It's a death penalty case. It's a quadruple homicide. This is nothing. This is nothing. Ann Taylor, too many delays. Get to work. Let's get this done. Oh, God. Let's give these families peace. Kohberger likes looking like a weirdo as usual. What? And they have had this case for years. This is BS. Get in with it. Not to mention the dollars on the taxpayers. Okay. All right. Kohberger did it. What do you mean he did it? He did what? He made it to court in a suit. Yay for Kohberger. January 6th deadline for defense for expert witness list. Okay. This dude should have kept judge. Lol, this dude's going to fed the wrath from this new judge is going to be amazing. Okay, let's keep in mind, guys, that this is the law and crime comment section. So there are some idiots on here. Like, this is very much a presumed guilty comment section. This makes me angry. Once again, he gets something else granted. This piece of shit should be in prison attire. Oh, really? Ooh, why does it feel like the court system is always on his side? Okay, so here's a little lesson. Presumption of innocence means that you're supposed to give him the benefit of the doubt right now. Goodness me. Goodness me. Yeah, Kohberger's in jail while they're putting it off, so it's not like it's a huge benefit anyway. Right, Travion? Yeah, I know. It's so stupid. It's so stupid. It's like, what difference does it make? Like, you're holding him in jail. What peace is it going to give you? They want him dead. That's what it is, Travion. That's what it is. They want him dead. So, I mean, it's pretty sad. But that is the truth. They want him dead. So, okay, if that's going to make them all super happy, I suppose. All right, that's it, guys. Thank you all for being here. I really appreciate it. I know, like, there's plenty of places you can watch this, and I appreciate all of you listening to my blaring on, my blah, 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 blah. I would say to you, any case at all, whether it be this, whether it be this, oh my God.
It felt like somebody had taken a baseball bat to my shoulder.
I turn up because the gun goes off. It's supposed to be a cold gun.
There was an incredibly loud bang. I just keep insisting, you don't understand because this is not possible. It's just not possible. There's a live round. It's not, it just can't.
Well, I show Detective Mark.
2 people were shot on Alec Baldwin's movie set. One of them is dead. So how did the live rounds get on the set? Plus, Tupac Shakur murdered 27 years ago. This morning, a music producer and friend of his is joining us live on the show. And search teams recover the body of 13-year-old Madeline Soto. What evidence might her autopsy reveal? It's all coming up next for you, plus much more right here on Opening Statements.
I'm so sorry. Oops. Oh, man. I'm so sorry, guys. I just boomed so bad. You can hear me now, right? Yeah, I'll blame StreamYard. No, actually, I'm in Dali's stupid software. Okay, yeah, I'll blame Dali. I'll blame hanging out with Dali. Hey, shut up. I'm so sorry. Oh man, I'm gonna go back and edit that. What was that? I've got this really good sound booster, but the problem with it is it goes off by default. Like you've got to stop it from going off. Yeah. Oh man, I'm so sorry. Anyway, David. No, I did not mean to end the stream. Okay, so David, I'll answer your question. David said, so funny. It's like, literally, I thought I got used to streaming like 6 months ago, maybe 8 months ago. I've been doing this for over a year now. Do I have a standing invitation or a mandate to appear for the Boone trial? It's a mandate. A mandate. Do what you want. Do what you want. I assume you're not streaming it. Like, you did say you were going to stream it, but I assume you're not streaming it anymore. You're just welcome. Come along if you feel like it, if you want to. You don't have to be there all the time. Sometimes, maybe, if you want. Do what you like. So yeah, we're streaming the Boone trial every night from 6 p.m. every trial day on this channel in fast mode. Damn it, you're putting it on the channel. Good. It'll be nice to have you. You know a lot about the Sarah Boone case, and you think she's innocent too, right? You're absolutely not streaming it. Good. Yeah. Well, I mean, not good, but I didn't think you were. But I'd like to have you here. That'd be sweet. And we're going to have so much fun, and we're going to do trivia, court and quiz every night. But yeah, just come along whenever you feel like it. You've got the keys to StreamYard. You can come in. Yeah, and tomorrow we have the hearing, so we'll run that also at 7:30 as usual. But just whilst the trial's on, we'll start at 6 p.m. each night. Dali's going to do a daily wrap up just prior, so at 5, of the highlights of the day, and then we'll do the actual trial stream each day. No breaks, no sidebars, no nothing, except just at the end we'll do a court trivia. It'll be fun. So we should be able to get through each day in a few hours, 3 to 4 hours. So it should be really fun. Yeah, nice and easy. It'll be fun. You did have a partner for the stream, but she wandered off to Kentucky, got lost in the hills with some backwater hobo lawyer. Yeah, I won't do that. I promise. And yeah, justice for Sarah. I'd really like there to be a Baldwin moment for Sarah, just so I can see everyone seethe. I wonder if the whole hearing tomorrow will be Zoom. Cacciatore might get caught in the hurricane too. Oh my God, please no. Just the court audio is so bad. Innocent. Well, you never know. Oh, we may have Andrew Brunker pop on. He is invited. He is coming home tomorrow from his big long road trip, and he's really interested to come on and give us his thoughts on the whole battered spouse thing. So yeah, he's invited, but depends. He's just getting home tomorrow night, so he might be a bit tired, but he's going to come on to one of the streams at some point. So yeah, had a bit of a chat to him, and he's very interested to give his thoughts. So maybe might have a bit of a Branca bomb, as in, bomb in the stream. Anyway, that's it. Last time. That's it. Enough. I'm done. It's time for the song. It's time for the song. It's time for the song. Thank you all for being here. And my daughter's going to get annoyed. I'm going to start playing this, and she's going to be like, "Don't play that stupid song, Mom." Her name was Ella. She was an Aussie. She was a fake lawyer from the future.
out on YouTube and make some live streams. The co-host is Darby and she dances sometimes. The words are always so loud and because she's an 803. To be citizen.